really the pleasure to hear to Dr. Tanya talking about the BNS in so much of detail. What I was amused was that somebody from the audience raised the point, what about the outraging of the modesty of a man? I could not see who raised that question.
Sir, there is a movie, Disclosure, you can see that. The movie Disclosure, Hollywood movie, Michael Douglas is there, starring Michael Douglas.
I will definitely go through, sir, but we have yet to catch up to Hollywood standards. I'm sorry?
Yes.
Okay. I was pretty much... I will take that list of movies. I will go through if I could get some time. But what I was on the point, why I said that I was amused by that suggestion. Because the Supreme Court of India has categorically defined modesty. And we men, as of now, are so crude to even have modesty. Forget about getting outraged. So that is the reason I said, listening to that outraging of the modesty suggestion is that first of all, we men will have to earn some modesty before being entitled to have been outraged. Because let me tell you, before I begin with BNSS, that I have yet to find a better definition of women in the literature. At least 2 languages I have command over to have gone through the literature. Though I have read a lot of Marathi literature, a lot of Gujarati literature, a lot of Tamil literature, but translated. The original literature in English and Hindi I had gone through, and I'm yet to find a better definition of women in literature what Supreme Court of India has defined. And I'll just tell you, and you would be spellbound, what the Supreme Court has talked about. Modesty and woman. That's why I said I was amused. One line definition of woman the Supreme Court of India has given, that a woman is modesty personified. That's it. Can you beat it? The entire literature cannot beat it. And the day I had read this, I had shut my book, pondered for half an hour, that can somebody be better literary giant than the Supreme Court of India given a one-line definition of a woman by simply stating a woman is a modesty personified. And that is where outraging, if you interpret, which was an IPC 354 ABCD and all that, it included in that KPS Gill judgment that outraging the modesty of a woman is not dependent on touch. So that was the defense of KPS Gill, that I did not touch. So how can I outrage the modesty? And that's where the Supreme Court had come heavily and stated that outraging the modesty of a woman is not dependent on touch. It can be outraged even by a blink of an eye.
Sir, but he had touched, sir.
He had touched in KPS Gill, that's right. Yes, you're right. There though he had touched, an innocuous touch it was, but there he had touched, but the Supreme Court went against. That's what I'm saying, that was the Supreme Court went against. It's not even dependent on touch. You're right. It was a touch on the shoulder. But it was just a pat, that how are you kind of a thing. But what I'm saying is that even a blink of an eye an oogling sound, a whistle, a remark, even staring, not even blinking an eye. If you just keep staring a woman, that is outraging her modesty. So,
For application of 354, at least there should be a use of criminal force.
outraging her modesty is not dependent on criminal force, sir. There is no, let me correct it. There is nothing related to criminal force for 354.
On 354.
That's what I'm saying. Outraging modesty, where will be the criminal force of a blink of an eye? 509. That's right.
He got 354, some act, some use of criminal force, or at least
No, sir. If you see ABCD,
For 509,
Just
that is not required.
no, that's what I'm saying.
For application of 354.
Just a second. I'll clarify. ABCD when it is added,
No, I am not on ABCD, I am on plain 354.
354 is one.
Yes.
When ABCD was, it was more in the line of 509 when it said that even peeping, voyeurism, stalking. And during stalking, where is the criminal force? In the voyeurism, there is no criminal force. That's what I'm saying. That those ABCD were included in the line of 509 but added to 354. It could have been in 509 ABCD. Now, that is what I'm saying, that those voyeurisms, those stalkings, those now it is also included in that sending electronic and digital messages. All that clears that outraging the modesty. Now coming back to BNSS, Bharatiya Nagrik Suraksha Sanhita. I'm sure Dr. Tanya will take you to that aspect in a longer, detailed manner. I shall touch certain points and will seek your permission to leave thereafter because I have to catch a flight. Bharatiya Nagrik Suraksha Sanhita, how it is different from CRPC. Like I said, that Bharatiya Saksha Adhiniyam predominantly retained most of the principles of Indian Evidence Act. Similarly, Bharatiya Nagrik Suraksha Sanhita predominantly carry forwards the procedure criminal jurisprudence of CRPC, with few exceptions. And this was again need of the hour. And they are more in the line of transition of digital and electronic era. Like, for example, the inception of a criminal jurisprudence begins with lodging of an FIR. Now, what metamorphosis change had happened into Bharatiya Nagrik Suraksha Sanhita is there is an attempt being made to dilute the jurisdictional part, which was the biggest impediment under CRPC. For example, there was always a challenge to register an FIR, and the police used to give us an excuse कि अच्छा ये crime सड़क के डिवाइडर के उस साइड हुआ कि इस साइड हुआ, और अगर डिवाइडर के उस साइड हुआ तो वो वाले थाने में जाओ, इस साइड हुआ तो यहां आ जाओ. And as if that was not enough, they would carve out some invisible boundary line. Oh, आप तो उधर चले. Now, that creates in my mind so many amusing situations when I used to undergo these situations. What if somebody attacks the other one? and the other one starts running to protect oneself. Now the beginning of the attack happened from this side of the divider. The man ran to that side of the divider, ultimately was hit on the other side. Then after getting hit on the other side of the divider, he further ran to escape and fell upon the third territory. Is it not a very amusing situation that everybody is raising hand? नहीं, वो तो आप देखो उधर गिरे. ये बोले अरे इधर गिरे तो क्या हुआ? वहां से शुरुआत हुई थी ना आपको दौड़ाने की. पहला अटैक वहां हुआ, उधर चले जाओ. And this used to happen. Now that is where Bharatiya Nagrik Suraksha Samhita has addressed this issue and attempted to dilute this jurisdictional aspect by two methods. First of all, now you need not even to go to police station to lodge an FIR. By taking the advantage of this digital electronic era, once BNSS comes into execution or enforcement, there will be a process of lodging FIR through net. So once you log in, who will come to ask you कि आप चौराहे के इस तरफ थे कि डिवाइडर के उस तरफ थे कि सड़क के उस पार थे कि जंगल के इस पार थे. It has to be through internet and the FIR would be registered. Thereafter, it would probably be look out of some centralized control room whom to refer it to which police station. So now with this change, if a soldier is deployed on a border, receives a phone call from his village, from his wife, that somebody is trying to break the housebreaking is happening, or some theft is happening, or some kind of scuffle is happening. The soldier standing somewhere on the border need not to feel helpless and keep shouting on his wife to do something, rush to police station. No, you need not. If he is in Srinagar and his house is somewhere in Telangana or Kerala, from Srinagar he can lodge an FIR. This is one big leap which Bharatiya Nagrik Suraksha Samhita will bring. I heard Dr. Kanya while talking about ITC or this BNS. She touched upon FIR. I was keenly listening. And she mentioned that now there will be preliminary inquiry for lodging FIR. There are two aspects of it. Because there were several judgments of the Supreme Court which said that in certain offences, more particularly in matrimonial offences, police should go slow. The police should not jump the wagon that as soon as somebody comes to lodge a FIR in the matrimonial dispute, register an FIR, start arresting entire family members, because that will have an effect of permanently shutting the door of reconciliation. Everybody will be so agitated that हमारे घर की बहू ने हमारे परिवार को कैद करवा दिया. Now, even if the husband wants to patch up, the saas and the sasurs and the nuns and the bhojais are against it. And they may start pestering that husband that, are you so helpless? That the lady who put in that entire family behind the bars, you want to patch up with her? Therefore, the Supreme Court had brought up this concept of directing the police to go slow and conduct a preliminary inquiry whether there is a seriousness to the level of lodging an FIR, because if we remember, original IPC did not have 498A. That has been later added somewhere in the year 1988. Dowry prohibition and the presumption of all that. And there was so rampant 498A proceedings because it was kept under non-cognizable, cognizable, non-bailable offense. And even if the marital couple finally want to patch up, the courts were not having the power because it was not a compoundable offense. So ultimately we used to be approached by those criminal litigants and we had to file 482 provision petition before the Honorable High Court to allow us to patch up and to withdraw the FIR because it's under the non-compoundable provision. And therefore the Supreme Court tried to nip the bud at the very inception by stating that please do not rush to register FIR as soon as somebody approaches you under 498A. Conduct a preliminary inquiry. So for conducting a preliminary inquiry, what method was devised? By the direction of the Supreme Court, CRPC was amended and section 41A was inserted. That the police will issue a notice to the other side. Now this 41A itself was so confusing. Because subclause 4 of 41A said that if the policeman considers that the arrest is necessary, earlier portion said that if on the basis of notice somebody appears, he will not be arrested. But later it says that if the police considers that the arrest is impending and he must arrest. So trust me, this was such a poorly drafted provision under CRPC 41A that when somebody approaches us in the office, sir, I received a 41A notice. The first advice given to is go for anticipatory. So you can't be sure. If the policeman is antagonized, he will take the later subclause into operation and say, I think you must be arrested. Who will take risk? So despite 41A, on the direction of Supreme Court, amended and added into CRPC, it was so poorly drafted that despite in the earlier portion of 41A giving a total protection that if you comply with the notice of 41A, you will not be arrested. Then why do we add this last line that in case the policeman feels he can arrest? So that created a very catch-22 position and that would not help judiciary from the lesser burden. Judiciary was rather more burdened with this 41A notice that every matter went for the anticipatory bail before the Sessions Court or the High Court. And then when the notices were issued in the anticipatory bail, the police will go, no, we don't intend to arrest. And therefore, on the very first day, the disposal happens. Why not that line could not have been there? If 41A notice the police is issuing, it should have stopped from there, period. You will not be arrested if you comply with the notice. That's it. So sometimes Dr. Tanya is right. Even we as a practicing lawyers wonder what goes in the parliament's wisdom, or parliamentarians, what do they think of putting everything in one cup, which ultimately puts the burdens on judiciary. Though we as a lawyers are very happy being flooded by new clients on everything. Our pockets swell, but the burden on judiciary is punishing. Yes, that's right. Whoever commented. That's very right. We actually do not have the system in India, otherwise we would have shared it.
But we get disposal.
I'm sorry?
We get disposal in bail applications.
Because of the police coming and saying that we don't intend to arrest. Anyway, going forward, that there was a system prevalent under CRPC called zero FIR. That was already prevalent practice. Now it has been mandated by statute under this Nagrik Suraksha Adhiniyam. One more aspect which I want to touch before I leave, that is the issuance and serving of summons. That has been quite archaic procedure prescribed under CRPC. And there used to be a rampant practice prevalent. Everybody knew, everybody understood that the summons are avoided being served. Though there was a Justice Oak's judgment of Bombay High Court, which had directed that you can serve the summons through WhatsApp also. And the moment there were 2 blue ticks, it would be considered by the court to have been served. Fortunately for us, 1st July onwards, this will become a statutory truth, because Bharatiya Nagrik Suraksha Adhiniyam has incorporated the summons to be served electronically. So now, even summons sent through email, though we don't have that blue tick system in email, but the presumption lies that the moment email is sent to the right email address, it is served. Now the burden shifts to the other side to come and prove that this was not the right ID or whatever, so I could not get it. That is a remarkable leap, because that will accelerate the criminal jurisprudence. That avoidance of summons, etc., would be now the matter of past. So it could be quickly served and one could proceed further. One more thing has been added, that the concept of Parda Nashin lady is no more there, because that era is gone. So now the summons can be served upon the major female family member of the accused. Earlier, one has to be a major male member. That Parda Nashin concept is done with. So even if the summons are served upon a female, it will be considered as served. So these are the developments as per the current era. So that, as I said, that as per my primary reading and research on these statutes, there may not be major principal changes. As Dr. Tanya has also rightly stated, that principally the idea of all the criminal jurisprudence remains the same, and there's no kind of metamorphosis change on the principle side. It's simply that it is to be in tandem with the race of time. That in the current era, the development of electronic and digital era, we have to be in race of time. Principles remain the same, and I could not agree more when she said that actually when we were indulging into metamorphosis, change of the criminal jurisprudence, we could have applied our mind better to have brought some actual changes in the principles also. And they were much needed. Even humble practitioner like us could understand that there needed changes, but they were mostly cosmetic changes. Some of them, like these electronic gadgets and all that's incorporated. As I mentioned during Bharatiya Nagrik Adhiniyam, that now it has become an evidentiary value of electronic gadgets and all. Similarly, in Bharatiya Nagrik Suraksha Adhiniyam, I would have loved that if the trial procedures would have been expedited. That would have been a principal change. But the trial procedures are identical from CRPC. There are to be sessions trial, there is warrants trial, then there is summons trial, and then there is summary trial. It beats logic that when we were making such comprehensive changes in the law and we are bringing new laws, why could not we have applied some mind to have expedited these trials? We could have curtailed those adjournments on flimsy grounds. We could have given more emphasis for the fast track disposals of the trials. What also is my humble kind of opinion while reading these Bharatiya Nagrik Suraksha Adhiniyam, that while you might have heard while IPC was that Bharatiya Nagrik, that Bharatiya Nyaya Sanhita, that a community service is added. If you read, most of the punishments remain the same. Death, life, then imprisonment for a term, then fine, forfeiture, and added with community service. I would have loved that we were innovative enough to have added. Firstly, we should have defined community service in detail and could have clubbed with offences what community service you are supposed to do if you are doing this. And why not a concept of compensating the victim has to be there. What happens is, in my experience as a lawyer, I have found that if you initiate a criminal trial or a criminal complaint, the complainant is more harassed than the accused. Because first of all, he has to struggle to lodge a complaint. If he succeeds in lodging a complaint, then there is a struggle of servicing of the summons. If he succeeds in serving the summons, then the accused takes bails, but in a criminal jurisprudence, the presence of the parties is necessary, so the complainant has to be present on every day. So what has, in turn, I have experienced is that the complainant is more harassed than the accused. What if the accused is absent? Now that has been taken care of, that in absentia also the trial will go on. But mind you, here it is not absolute. It is with a catch that if the accused absence from the court after being proclaimed, then the trial will go in absentia. That means, if we remember old CRPC, which is still till July there, up to section 82, the pace remains same. The proclamation happens under section 82 of CRPC. And once being proclaimed offender, thereafter the trial can go on in absentia. But that was taken care of in the 369 even otherwise. You have to just separate the trial and go on. So with this cosmetic change they brought in, the trial will go on in absentia. What I would have loved, that even after you serve the summons, there will be no further dates if the accused remained absent. At the moment, framing of charge is also dependent on the presence of the accused. Can the court frame the charge in absentia? I have handled several cases where the accused is not present and the court every time says that secure the presence of the accused. The charge cannot be framed, despite the charge sheet being before the court. So the framing of charge is also dependent on the presence of the accused. The whole system is pro-accused. And the harassment is through the complainant. So I would have loved if this pace would have been little more speeded up. Then we would have been actual Bharatiya Nagrik Suraksha Adhiniyam. If the emphasis, as been told in the parliament, is not on penalty but on justice, from Dand Sanhita to Nyay Sanhita, from criminal procedure to Nagrik Suraksha, then I think that they should have defined which Nagrik Suraksha. The Nagrik who's coming to lodge a complaint being victim of a crime, or the Nagrik who's accused of committing a crime. Whose Suraksha are we talking about? Because that aspect has to be taken care of. Though I'm happy that Bharatiya Nagrik Suraksha Sanhita has taken care of these electronic and digital things to have emphasized on the speed of things. Those preliminary inquiry has now brought into the legislation, which was only direction of the Supreme Court, and 41A was haphazardly drafted. But it would have been better if we would have taken care of complainants' agony more. There are many more changes which has happened in CRPC, and I'm sure Dr. Tanya will go through you with those aspects, because it was decided that I'll touch certain portion of Bharatiya Nagrik Suraksha Sanhita, rest she will take care of it. So these are the aspects which I wanted to highlight. Before I leave, just one more thing, that now one important change which has taken place in Bharatiya Nagrik Suraksha Sanhita is that the trial can be conducted online. So through video conference, the entire trial can be conducted. This is one more good development. So gone are those days जब फिल्मों में हमने देखा कि जेल से गाड़ी निकली और रास्ते में पलट गई, या किसी ने अटैक किया और अक्यूज को छुड़ा लिया और लेके. This was invariable in every film. With this new addition of incorporating video conferencing trial, the accused will remain behind the bars in the safe confines of the jail. He need not travel to the court. And what was during TADA provisions, I remember, that either the judge used to go inside the jail to conduct that trial, or most of the courts were conducting through video conferencing. The giant screens were, the television screens were fitted in the courtrooms. Now it has become a reality by statute. So this is one more good development which I wanted to share, because we are analyzing it critically, good things as well as certain aspects which could have taken better. So I'm just saying that this is a good development. Now this helps one more thing, that if the trial is being conducted through video conferencing, even the lawyers need not to be present in the court. So one can conduct a trial from sitting in the office. So he cannot take adjournment that I am busy or I am going to this court or that court. The court can say you can conduct it from wherever you are. Even if you are not out in town, you cannot take a defense that I am traveling. Now through video conferencing you can conduct a trial wherever you are traveling or wherever you are stationed. You can't escape that. So this will also help in speeding up the trial. So these are the smaller areas which I wanted to cover before I hand it over to Dr. Tanya, who was brilliant when I was listening to her, and she'll definitely give you better perspective of a professor like teaching to the audience. I would love to have sit and heard you, Dr. Tanya, but unfortunately I'm not that fortunate. I had to rush. My flight is there, so I'll take leave of all of you. It was a great honor to have addressed such an august gathering. Thank you so much once again. Jai Hind.